All right, good afternoon, everyone, and welcome to another meeting of the Public Safety Subcommittee for the House Judiciary Committee. I'm Nicole Williams and your chair, and I guess we will go ahead and get started. The first bill that I have is House Bill 575, which is the Victims' Compensation legislation. And so, let's see here. And this is one of the administration bills. And I see we have a couple folks here from the governor's administration. I think we have joining with us Miles Hicks as well as Dorothy Lenning. And so my understanding, the Senate version of this bill, Senate Bill 471, I believe the Senate adopted some amendments to this bill. So that might be helpful in maybe starting the conversation. And Council, I see Claire is on. And so Claire, I don't know if you have the amendments from the Senate side, if maybe we can maybe start the conversation there, if you can just provide us with an overview of the amendment.
The people in the governor's office might be the better people to discuss the background behind the amendments because I wasn't involved in those discussions. Apparently, they spoke with counsel for the Judicial Proceedings Committee. I don't know that the Senate, I don't know that these have actually been voted on yet.
Okay.
Maybe the governor's office
shaking his head no.
the status.
Okay, so Miles, do you want to kind of give us an update as to where we are with both the House bill and the Senate bill? And first, like I said, I have in my notes amendments, so if we can get a clarity as to what that means, that would be great.
Yes, and I'll also pass it to Dorothy after I'm done too, because she also has had numerous conversations with both committees as well. So what you have in front of you, amendments that you have in front of you are actually amendments that, yes.
Can you speak up? I'm sorry, Mr. Hicks, if you could speak up a little bit, you sound really far away.
Yes, so is this better? You guys hear me better now?
Yes.
Yes. So the amendments that you have in front of you today are amendments that were drafted by the JPR committee. We just have your subcommittee scheduled first. So there's no actual amendments that have happened to the bill yet. A lot of the amendments that are being made are specifically around the process that was discussed during the hearing around employees of GoCap's ability to be the first level of approval, and then appeals going to the actual board. So this was just recommendations by committee counsel to make sure that the language in the bill also matches the intent that we discussed. With that, I'll turn it over to Dorothy to provide any additional information or to correct me if I was wrong.
Okay, thanks.
So no, everything Miles said is right. I met with the committee counsel after we had our bill hearing, and he was concerned at the enormity of doing the piece that I was working on about really changing the role of the staff and the board. And he felt that it was going to be awfully hard to do in this bill at this time. He thought the roles that we could do, everything I wanted to do in the existing form, and then use the interim to decide if we wanted to do a bigger, more codified version of it. And I think he was right. As Miles and I walked through it, I was getting a little nervous that we were in, what's that expression, we were like over our skis or something. Like we had just tried to move it all too quickly. So I think this bill does everything that the advocates and the governor intended us to do. We can decide then moving forward if we want to change any of the more structural parts of how GoCap runs the office.
Okay. So, yeah, and I'm looking through the Senate version of the bill, which I don't think this includes the amendments that, I have to double check.
So I think your office sent it around earlier. I don't know whether it was it the
okay, so this
yes, it was an email that I think we
okay. All right.
Yeah, so
Um,
none of the amendments have been voted on or added to the bill. These are just amendment drafts that you guys have.
got it. Okay.
And so are you saying, Madam Chair, if I could ask, are you saying and I asked if I could ask, and then I just kept talking, and I apologize.
You're okay. Go ahead, Delegate Phillips. You can ask your question.
Thank you, I apologize. Are we saying that the administration is supportive of those amendments or not?
They're nodding their heads yes.
Yes,
I
we,
think-
su- we support these amendments. They're very minor.
Okay.
Most of the change, it really didn't change that much. So,
Okay, so
and I think that this amended version is better than what we originally put in.
okay. So I see, it looks like the first change is on, if folks want to follow along, that I'm noticing, and please correct me if I'm wrong, on page 5, starting at line 23, going down to line 26, and just deletion of that new language is the first one that I have. Oh, is
And-
that correct?
Yes, and if I get, the conversation I had with counsel was that he believes, and I think he's right, that
Mm.
the board can ask the staff to do most of the
Okay,
work as it is, just like a judge might give a law clerk an opinion to draft and then the judge
Got
signs it. And so he felt like we already had the ability to do this.
okay, and then I see the may on page 6, and then the rest of the language the same. So I guess that's just going to what you were just saying there. Okay. And I think, let me just make sure, I think that's all that I saw, but let me just double check myself. Okay. Yeah, those 14, 15, the possible, that new language. Claire, yes, I see your hand.
I just wanted to ask Dorothy and Miles about that second amendment on page 6 where it changes shall to may. Is the intention to make it optional for the board to submit the annual report? Because that's what it's doing. It says the board may delegate to employees the authority to blah, 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 and submit this annual report. Is the intention to make that optional?
Well, somebody has to submit the report. So I'm guessing that should be the shall that about submitting the report. I think whether the board delegated to the employees went from a shall to a may. You agree?
Okay, I can make that change if that's what you all want.
I'm looking at Miles to see if he wants to chime in here.
I think the report is a requirement. It should be a shall. The report should be a
Yeah,
shall.
okay, yeah, because that was
That's,
changed to a may.
yeah.
on the
So
second.
it should be the delegation portion should be may. The reporting portion should definitely be a shall.
Okay. Okay.
Thank you, Claire.
Thank
You're
you.
welcome.
Thank you, Claire. And
Yep.
then the third amendment that I see from the Senate is on page 15. On the reprint, it starts at line 10, where it just adds a little bit of additional language about the claimant may petition the board for reconsideration of a decision made by the board or an employee of the board. And I'm okay with that language.
So if I may, the idea was originally what I was hoping to do was have the staff make the first level decision and the board be the appeal. And because we kind of realized we probably couldn't do that all at once, This would
Good idea.
allow the board officially to make the decision. You know, the staff could make the decision, the board would then say, yes, that's our decision, but they could also be the first level of review because they could be asked to review their work. Apparently, there's another agency that does it that way. And so that, I think the MSP does it that way. And so
Okay,
they thought it would work.
okay. All right, well, all of the amendments from the Senate side seem pretty reasonable to me. Claire, I see you still have your hand up. I don't know if you have another question or a comment.
No, sorry, I just forgot to lower it.
Okay, no worries. All of those amendments seem pretty reasonable to me. I don't know how other members of the subcommittee feel about those amendments. Seems good. Okay, we'll do a more formal vote in a minute. The other thing that I wanted to bring up about the bill in general, so this is good to know that the Senate has looked at. Do we have a sense about when they're going to vote on this by chance?
So from what I understand, they were waiting to hear from B&T because it has a large fiscal note. I'm hoping it's on, I haven't looked to see if they've posted their voting list for tomorrow, but on every voting session, the chair talks about, he's just waiting to hear from B&T.
Okay. Okay, sounds good. The other questions, well, let me do this. Do any of the members of the committee have any questions for Ms. Lenning or Mr. Head? Nope. Okay, everyone is, you know, don't have to jump up at once. Okay. All right, well, I do have a few questions, and I think I mentioned this during the bill hearing. There were two letters. The more robust letter was favorable with amendments regarding from the Maryland Association of Social Workers, as well as it was the social workers, the licensed therapists, and the dentists. And they wanted some modifications with regards to the language, I think starting on page 3. And I think I'm somewhat in agreement with them. The sense that I got from the hearing was that I think the administration would be okay with the language that they were proposing. And if you need me to go back to their testimony, I can. But it had to do with just kind of the definitions as it related to the physicians, the health occupation professionals. The dentists just wanted to be included because sometimes maybe dental care might come up with a victim. So I wasn't certain if you all had any comments or concerns about that. Yes, Dorothy. Oh, sorry. Yes, Ms. Lanning, I see your hand.
So I know at the hearing, we talked about that it probably would be okay, but then I went back and thought about it. There are at least 2 other places in the code that use this definition of qualified third party. One is in, you know, victim of domestic violence or sexual assault, having to get out of a lease. And the second one is for getting out of a utilities bill. And I'm concerned that if we start to change the definition of qualified third party, that it's then going to be inconsistent in other parts of the code. And so that's why I hesitate to do it here.
Okay, so in the other sections of the code where it has qualified third party, they actually use the phrase social worker and caseworker?
It's bills I've worked on, and this was the exact language. And we're just, you know, when I was at House of Ruth, I was working closely with Melanie Shapiro, and we very carefully put the exact same language in the other places, and that's where this language came from.
Got it. Got it. Understood. I guess the concern I have is that because on the first line under G1, we talk about a licensed physician or psychologist authorized to practice under the health occupations article, and I think that's fine. But we don't mention the same for the licensed social worker, which is defined under the health occupations article.
Okay.
Delegate Tolles, if you can mute
For the
yourself.
bus and for the dancers.
Delegate Tolles.
And we need to start laying out what
Can we mute Delegate Tolles? Thank you. Okay. And so I feel like if we're going to talk about social workers, then we just need to make sure that they're licensed and just maybe add the same language that we have under G1, that they're licensed under the health occupations article. But also under the health occupations article. And like I said, I completely understand where you got the language from, and maybe we need to think about updating those other sections of the code. There isn't really a caseworker per se as defined. I couldn't find it anywhere as defined in the code as to what that is. And so I didn't know if you meant licensed therapists instead of a caseworker, but I guess that was what kind of stood out to me when I was reading this section.
I mean, I think this came from the domestic violence world where we have staff members who are called caseworkers who are not LCSWs. I think we were trying to make this part broad, particularly, somebody comes into a victim service organization, they might not necessarily be a licensed, like a licensed social worker but it's somebody who's working with victims of violence a lot. And so we're trying to make it broad. We wanted them to be able to say, yes, I'm working with this person, we believe this is what happened, we're supporting their claim.
Right. Okay. Okay. Well, like I said, I just wanted to raise that up because like I said, that was my concern that I had with the language. And I, was reading the letters from those entities, and I feel like that made sense, because it references back to another section in the code. They're under G2 and 3. The other thing, and what about the dentist piece? Because that was a separate letter that was submitted favorable with amendments. And I can easily see a victim, if something happens, they, where they need to have teeth replaced, oral surgery, something along those lines. I mean, I think it's a reasonable thing to add in there as they are separately defined in the health occupations article.
The way I'm imagining this, the person would have to come in and prove that a crime was committed and that they were a victim and that they had some reimbursable expense. So if somebody comes in and showed us a bill from a dentist because they had their teeth knocked out, and a newspaper article saying, somebody beat them up, that would be enough to put it together to say that we believe the crime had been committed, that they were the victim, and they have this reimbursable expense. The qualified third party, I think, was to add an additional element to people who use really these victim service organizations. So it wouldn't exclude a dentist in any way from being able to support somebody's claim. We certainly wouldn't throw that out. If you think it's important to add that as number 4, I don't particularly have a problem with it. My only concern, like I said, was these other places in the code that use this definition, and now this would start to change it. So I want everybody to just be aware of it, of kind of the impact it has.
Got it. Hi, Mr. Lukey. I see you've joined us. I didn't know if you had anything else to add.
Yep, just full faith in what Dorothy's saying.
Okay. All right. Do any of the other members of the committee have any additional questions? The other thing I had a question about, this was in the original bill. I had a note, page 4, lines 12 through 15. We have, and this is just really a semantics thing, unexpected funeral expenses. How would someone prove that the funeral expenses were unexpected? And do we want to make people go through the rigmarole of proving that they were unexpected? Oh, Claire, now I see your hand up. I'm going to assume this time it's on purpose.
I just wanted to point out that that is in just a policy statement. It's
Okay,
just a finding. It's the lead in is the General Assembly finds 1, 2, and 3. So it's just not really substantive.
okay, all right. That's fine. Okay. All right. Any other questions from members of the committee? Okay. Claire, I guess my next question is just more procedural in nature. We have these proposed amendments from the Senate. How should we proceed? I mean, should we maybe hold to make sure the Senate adopts these amendments before we in turn vote to adopt the amendments? Because I don't want to adopt them and then the Senate turns around and, I don't know, does something different or add some new stuff, or I don't know.
It's up to you. I mean, they probably want to do the same thing that we're going to do. So I would think that if we adopted them, they would, with the fix that we discussed,
Right.
that they would probably want to adopt them too. But I think that Ms. Lennox said that they're waiting on the Budget and Taxation Committee anyway. So it's up to you.
How does the committee feel right now about moving forward at this moment, or do we want to wait to see what the Senate does? Delegate Taylor.
Actually, I have a question that before I,
For sure.
comment on what you just asked. Have we had a discussion yet about the definition of loved ones?
We have not.
And so that is on page, it's referred to, I guess, on page 4, line 9.
Oh, okay, I see here. I think this is that same language that Claire was talking about that's not really substantive in nature, but just more. You said page 4, line 9?
Yeah. It's right above
Oh, I see what
section where you
For
referenced
government
earlier.
assistance for crime victims and their loved ones. I think that's just kind of, I don't think this is procedural language. Am I correct in that, Claire?
Okay.
It's just a preamble.
Right. Okay, I see
Lead
it
in
now.
like a policy statement. So it's not necessary to have a definition for those terms. And I think with regard to the unexpected funeral expenses, they're just trying to say, if somebody dies, a lot of times you don't expect it. So you're not expecting, you haven't budgeted for these funeral expenses.
Yeah. And I guess because it's not reflected anywhere else, I guess it doesn't really matter then.
And I believe later in the bill, we define who is eligible, correct?
Yes, it does.
Yeah, so.
Yeah, it says parent, child, domestic partner,
Yep.
dependent minor, adult under legal guardianship, or spouse of victim who resides with the victim, if I'm
Yep.
reading that correctly.
What page is that on?
I'm looking at page 8,
Ah,
line
and
9,
Yeah,
or this is the reprint. I apologize. Let me go back to the original bill.
I see it. Thank you.
Yeah, page line 11. Yeah. Okay. All right. Any other questions?
no, Madam Chair, I would first I would make a motion to move the amendments. And I
Okay.
would include, I would only include the amendment that came from favorable with amendments to add the dentist. I would not include the other amendments that were suggested from the other organization.
Okay. So you're moving to add in the amendments, the proposed amendments we've received from the Senate, plus also to add in dentist?
Yes.
Okay, all right, so we have a motion on the table. Is there a second?
Second.
Second.
Okay, it's been moved and seconded. Is there any other further discussion? Do we need to beat this horse anymore? No, okay. All right, so it's been, well, we didn't vote on the amendment, so I think we just need to do a voice vote on the amendments. Is that correct, Claire?
Yes, that's what you usually do.
Okay, so all in favor of the proposed amendments? Oh, Delegate Crutchfield, I see your hand.
Yes, thank you very much, Madam Chair. So I want to just make sure, so the Senate, so right now, what is the posture of the bill in the Senate?
They have not voted on the amendments or the bill at this point.
Okay, and when is that expected? I mean, is it on a vote list right now or not? We just don't know.
I don't know. I didn't
Okay,
really.
that's
It-
fine.
It's not on
I
a
shouldn't
voting
say I
list.
don't
That's
pay attention to the Senate, but I didn't really look to see what they have
No.
going on. Just
Yeah, no problem. I just wanted to find out where it was. Okay, got it.
no worries. Let me see if it's up on their website yet by chance. Today's the
And
26th.
yeah, I think Miles said no, it wasn't on a vote list, upcoming vote.
Okay.
no, in the Senate, the bill is as introduced.
Okay. Thank you.
Okay. They do have a voting, oh no, that was this past past Friday, never mind. They do have a voting session scheduled for tomorrow in JPR, but I do not see this bill on the vote list. I see some other interesting stuff, which we can come back to at a later date, but I do not see this bill scheduled for their vote list on Tuesday. All right. Okay, so all in favor of the amendment, say yay or say yay.
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 Yay. Oh, and now I see two hands. Ms. Lenning and then Delegate Crutchfield, then Delegate Tomlinson.
I'm just noticing it's on in JPR's vote list for Friday.
Okay. Okay, thank you. Oh, and then Delegate Tomlinson, oh, was that your just hand raised saying you were in favor of the amendments? Okay. All right, that's how Delegate Crutchfield lower her hand as well. All right, so we have approved the amendments as proposed in the motion, and that has passed. Everyone voted yay. Next, I will entertain a motion on the bill as amended.
Move the bill as amended.
Second.
Okay, it's been moved and seconded. And then I guess I will just call the roll, starting with Delegate Conway.
Yes.
Okay. Delegate Crutchfield,
Yes.
Delegate Munoz,
Yes.
Delegate Pastor,
Yes.
Delegate Phillips,
Yes.
Delegate Schmidt has an excused absence. Delegate Simpson,
Yes.
Delegate Taylor,
Yes.
Delegate Tolles,
Yes.
Delegate Tomlinson,
Yes.
and Delegate Valentine.
No.
Okay. All right. Well, the measure passes favorable with amendment. We have 1, 2, 3, 4, 5, 6, 7, 8, 9 yes, 1 nay, and 1 excused. All right. Okay, well, thank you all so much. All the governor's folks, I don't know who's sticking around from the administration on the next bill. But let's see here. The next bill is also an administration bill, and that is House Bill 585. And so I see some new people coming in for House Bill 585. This is the Protecting Election Officials Act of 2024. And I have on my list, Sarah David, Jared Damaris, as well as Eric Lukey. Okay, so I see Miss David. Eric is still with us, and then is Mr. Damaris here? Oh, yes, there you go. Okay, wonderful. All right.
Got a lot of sun.
So House Bill 585 is also an administration bill, and this is really to protect our election officials. from any threats or harm, as well as their immediate family members. And so I will first, I guess, ask if the committee has any questions for the individuals that are present with regards to this bill. Again, everyone doesn't have to jump up and down all at once.
Can we have a summary of some sort?
Oh, sure. I apologize. Claire, do you want me to give the summary, or I can just read the little preamble?
Sure, that's fine.
Okay.
Unless you'd prefer, it's up to you.
No, if you can give the summary, that would be great.
Sorry. So the bill just prohibits a person from threatening to harm an election official or an immediate family member of an election official because of the election official's role in administering the election process. And it makes that a misdemeanor, punishable by up to 3 years in prison and or a fine of up to $2,500.
All right, sounds pretty straightforward to me. Delegate Tomlinson.
Thank you. My question was for our Board of Elections Administrator. Question about the list of folks who this covers. Employees of local boards, election judges. I'm just trying to think back and remember as far as how technically the staffing works when it comes to election time. Are all the people working, or they're considered employees? They're not considered contractors or temporary workers. This is covering everybody that's working on election day and the day leading up and all that stuff. Thank you.
I'm muted. So, right. Sorry. So this bill, so this bill would cover the LBE staff and the election judges program there. So it would be the ones that are actually implementing it. Now, contractors like my vendors would not be covered by that, but that's different staffing on that front there and outside of it. But this would be everyone who is basically on the lines implementing and dealing with the public and dealing with voters that are part of the Maryland elections.
Who's picking up the at the drop boxes? Is that actual employed staff? Okay.
Yeah, so that's staff, and those are also, if we augment it with people that do have to take, it's kind of a strange thing, Delegate, it's if it's not the actual staff itself and they use like volunteers, those volunteers still have to take the oath of an election judge.
Okay, so they're covered.
So right, I think at one point here, I would say that because they took the oath of an election judge to go get the information, that they became election judges for that purpose. But
okay,
yeah.
Gotcha. I'm just going through my head and thinking maybe everybody's covered who needs to be covered. Okay, thanks.
No problem. Delegate Crutchfield.
Okay, thank you very much, Madam Chair. So just 2 quick questions then, and keep it in mind with the previous question. So we're really talking about also our short-term employees. You mentioned employees that take the oath, and I guess that's not really clear in the bill. So I'm just making sure that that's, again, the intent, short-term employees, because those are usually folks that are sitting there at the table when you go in and check yourself in.
Yes. So, and I believe Ms. David can help me with this here, but those people would be paid for by the county and thus become LBE staff. So, I guess there's a little bit different here rather than like a contractor that we would hire to say like service the equipment or something like that, like ES&S. They're not going to be covered by this, but the local board that augments its staffing with and basically the county, that becomes, they get credentialed, they go through all the process as if they were an LBE staffer during that time period, which would then cover them for that point of employment.
Okay, thank you very much. And then for our council, was there any unfavorable testimony on this bill?
No significant opposition. There may have been a couple of individuals who signed the sheet, but I don't think anybody verbally testified against it, and there were no like organizations that testified against it.
Okay, thank you very much.
Madam Chair,
Yes. Oh, yes, Delegate Phillips.
I did see the one note from the AG's office. I guess they were concerned that their counsel, though the individuals who are providing advice and counsel would not be included in any of these definitions, and that their information is publicly available as well. Does the administration have any concerns if we were to add?
Delegate, what they're pointing out is that under section A2, Roman numeral 3 of the bill, where it says employee of the state board, technically the counsel provided to the state board is an employee of the office of the attorney general. So we have no problem adding language clarifying that it also applies to counsel to the state board and the local board.
Okay.
Okay. All right.
And
Well,
that was, I did review the notes. That was the only comment favorable with amendments was that one, and there were no other unfavorable written testimony.
no, correct. All right, Delegate Tomlinson.
Sorry for asking another question. It's, between what Delegate Crutchfield and I asked, and the administrator's answer. With the contractors who actually own the machines, and I'm visualizing this, they show up in the morning with the key and they set it all up and then they come back at the end of the day. Was there any talk, or like what was the decision? What was the idea around not protecting them also under the bill? Was it just like too much, or I mean, I don't know if there's been any incidences in the country where they've been attacked, but I feel like they could maybe, I don't know, what was the reasoning behind not including them in this as well? I was just curious.
I'll just note that they're individuals that are not readily identifiable, like their name, like election judges wear their names and things. So obviously if they were assaulted or anything else, that's still a crime, right? That's still something that we can handle, but they're not individuals that are readily identifiable in their roles to be targeted in that capacity. I don't think there was any talk about specifically excluding them, but they're just not going to be. Do you see what I'm saying? Like they aren't going to be identified in that role to be targeted in that role.
Gotcha. I was just curious. So sorry, no more questions from me. Sorry.
It's okay. It's okay, Delegate Tomlinson. It's judiciary. Folks can get at least 2 bites out of the apple. All right. Any other questions? Delegate Valentine.
Thank you, Madam Chair. I just wanted to kind of zero in on the oral threat component. I have all the paperwork. I just feel like that is so broad, and I guess my concern is how someone would perceive an oral threat that would then turn them and make them suffer serious emotional distress, and how that would kind of work. I know that's kind of an open-ended question, but just in a real life scenario where something like that would happen.
So I'll say that just to kind of deal with the first point of your question, which is this isn't a reasonableness necessarily standard of the language of what is a threat, that's litigated. There's a lot of Supreme Court law on that. But as far as what would be an example would be, and I always use my own name in examples, but like, Sarah David, I'm going to come to your house. I'm going to send people to your house. I'm going to make sure that you're not able to work in the next election. You know, things like that, that are personalized rather than Sarah David, I don't like, you know, your political party, or I don't like the person running for your office. Those are kind of political comments. Does that help, or does that make sense?
That's a good example. Yes.
Any additional questions, Delegate Valentine?
No, I'll put my hand down, Madam Chair.
Okay, Delegate Simpson, and then I see Delegate Pastor.
I mean, isn't also the issue is that typically individuals are in their own neighborhood. So that's another issue. If somebody is threatening you and you're an election judge, you're more likely from that same area. And I think that would make it more fearful.
That's a great point. I mean, people are identifiable. And I think also, you know, these are fundamentally volunteers who are trying to protect the integrity of this system. So we do want to kind of make that extra effort as well.
Yeah.
That is a good point, Delegate Simpson. I know for our election judges, we usually have the same individuals who serve as judges every cycle, day in and day out, to the point where you start to get to know them and they start to get to know you, and everybody in the community knows them. And so, yeah.
Right. See them at the
Right.
grocery store or wherever else afterwards.
Exactly. Delegate Pastor.
Yes, thank you, Madam Chair. Delegate Valentine, if you will, can you, I heard the answer from Ms. David. Will you restate your question or re-ask your question? I think I missed something in it, and I would like to hear it in terms of what the answer was, please.
When I just talk about oral threats and how, and I guess the second component is harm includes serious emotional distress, and we all have different levels of emotional distress. What may distress someone else on this committee may not distress me. So I'm trying to think, how do we quantify that? And that's not like an injury per se. So the emotional distress may be at different levels depending on where you are and who you are, age and such. So I guess that's kind of, it just seems broad, I guess, is what I was getting at.
Mm-hmm. Okay, thank you. So maybe, Ms. David, I do need to hear your response to him again, because I agree with him. It is broad. So can you give your response again, please?
Well, and I'm sorry, Delegate Valentine, if I misunderstood, that's a slightly different question than what I had heard originally. The original question I'd heard was as it related to what would be a manifestation of an oral threat that would cause emotional distress. If the question is, how do we calibrate what is serious emotional distress? This is also language that's used in the stalking statute, and it has been litigated at the Maryland Appellate Court level. So I'm happy to kind of circulate the language. The case is State v. Schmidt. And so it is analyzed on a reasonable person standard, but it's analyzed with evidence. So this is an evidentiary standard that we have to use in many different capacities, and it's going to be the same capacity to prove that it was reasonable that this would cause emotional distress.
And this is something that we would be working with the state prosecutor's office about, and like so it's not all of a sudden I got a bad, you know, I look at it because I'm in the bill here, so it's a kind of strange, like it's not like I get a bad tweet and like someone that it upsets me. It would have to be something of a serious nature where I'd have to rise that it would be disturbing, that then I would go to the state prosecutor's office, and then we would have to start looking at it and how to build the case based upon the prior precedents on this as well. So it's not I would say yes, it looks general, but it's actually a very specific term of art.
And so may I, Madam Chair?
Yes, Delegate
Okay.
Pastor, and then
So
Delegate Valentine.
you don't then have to assess the necessary impact to it, whether it would bother one person versus the other. Is it in the language then that it is clearly a threat on someone's life, person?
Yeah, it's a reasonableness standard. And so it's, you know, I think that if I'm trying to think of a good example, if you said, Ms. David, I hate you and I hate your cat. And it happened to be that I had a disproportionate love for my cat, right? That's not a reasonable threat, right? That's not something that a reasonable person, even though if I personally was extremely distressed by the comment. What would be reasonable though, I think, is to use the example I used with Delegate Valentine, which is, Ms. David, I'm going to come to your home and I'm going to find your children and I'm going to make sure that you never work in another election and that they never get to vote. Right? That's not explicit. That's not, I'm going to come kill you. That's not, I'm going to come kill your children. But that's going to imply that heavily to me. And again, I think that as a prosecutor, I would say that a court would evaluate that as reasonably causing serious emotional distress to a person.
Okay. Or whether the words are could be construed as assault. I'm going to do this, or I want to see this happen to
Yes.
you.
And Delegate Pastor, you've hit the nail on the head. What we're trying to do is make sure that we're encapsulating that kind of step beyond the assault versus Sarah David, I'm going to come kill you. It's I'm going to make sure you never work in an election and make sure your kids can never vote. I'm going to make sure they never see school another day. That's what we're trying to encapsulate here.
Got it. Thank you. And thank you, Delegate Valentine, for that question. Thank you.
And then Delegate Valentine, it looked like you wanted to add something there.
I just wanted to add that I do have the case I was referring that Sarah was referring to. I was hoping, and she did answer this, who would investigate these? Or Mr. DeMarin has said this. If in a situation like this, is this going to be investigated by a certain entity once it reaches a certain level? We wouldn't be expecting like local or municipal law enforcement to investigate these type of cases, or who would be investigating? And the last question, I apologize. How many cases throughout Maryland did you see of this, say, in the last election cycle that necessitated such legislation? If you have a general idea or a ballpark.
So I'm going to take a stab at the first question first, and then I'll let Mr. DeMarinis kind of expand on some of the examples, but I think some of the first answer will help clarify some of that. So our office, the Office of the State Prosecutor, specializes in election law enforcement because there is no crime like this in the election law article or kind of encapsulated in our statutes that applies to election judges, that wouldn't have come to our office. It would have gone exactly like you said to a municipal or local person. And so this, by putting it in the election law article, will allow it to come to our offices. And we have a specialization in not only this law, but also in kind of that First Amendment analysis that we were exploring, in the discussion of emotional distress. As far as other cases, I know some were referred to our office that we couldn't do because of the law, but I'll let Mr. DeMarinis kind of comment on that. And I would also note that we would have concurrent jurisdiction with the local state's attorney. So if a local state's attorney wanted to prosecute this, we could investigate it and refer to them for the prosecution.
So, thank you. Basically, nationally, yes, it's more of a problem. In Maryland, we're a little fortunate, but we are not immune to what has happened nationally. We've had in one incident in Carroll County, a person, it was Doritos or something like that, but smash it up and send it into the office, along with the mail-in ballot application with a nasty note on it. So when they opened it up, it looked like a white powder that had fallen out of it at the time there. And, it caused the office to close and have hazmat come out there and move forward with it. We have been receiving, I would say, some other nasty notes that were directed at election directors and myself when we mail out a few of the mail-in ballot applications that have come back. And, I would say we've had some vitriol geared towards us about certain, maybe a presidential candidate that should or should not be on a ballot at this point here. So that's kind of where the status is currently, and what we're facing on that front.
Thank you for the answer. I was just trying to get a gauge statewide.
Yeah.
Thank you. Thank you, Madam Chair.
You're welcome. No problem. Delegate Pastor, I see you still have your hand up. I don't know if that's left over. Okay. Anybody else have any questions? All right, well, I don't have any questions. Delegate Phillips asked my question earlier about the Attorney General. So that was really kind of the only thing I had in my notes. So I guess at this point, if there aren't any other questions for our guests, I just want to make sure one more time. Okay. All right. Well, thank you three for being here. We really appreciate it. Really appreciate it.
Thank you.
Thank you. All right. So I will entertain a motion to move a motion for the amendments, or just the one amendment that the Attorney General is requesting, which I'm looking at the letter now. They want us to add the Assistant Attorney General assigned to the Maryland State Board of Elections and the Assistant Attorney General who counsels the Baltimore City Board of Elections.
Madam Chair,
Yes.
I move the
Delegate Taylor.
amendments.
Okay, is there a second?
Second,
Second.
Okay, all in favor, say aye or raise your hand, one of the two.
Aye.
aye.
Aye, aye. I guess I can't vote twice. Those opposed? Oh, Claire, I see you have your hand up.
Yes, could you, I just had a different wording. I thought
Oh,
the
sure. What's your wording, Claire? I
Office of the
appreciate it.
Attorney General and the official who spoke a few minutes ago said counsel to a local board of elections and counsel to the state board. But
Okay.
you said the Attorney General, what was the language you used?
Yeah, I was going by the language that was in the letter from the Attorney General.
Oh,
But
because
I think yeah, but I think your language is probably a little broader and probably makes more sense. Because what you're saying is the Assistant Attorney General assigned to the State Board of Elections, as well as the Attorney General assigned to the local Board of Elections, which would encompass the county officials as well as Baltimore City, I think, if I'm interpreting that correctly.
I thought I got my language from the Attorney General's testimony. I'm scrolling through.
Okay. Sorry, like I said, I was just reading the letter, so I
Which
didn't.
letter are you
The
reading?
Attorney General's letter.
Okay, I'm looking at
Oh, go ahead.
Adam Spangler.
Yes.
The Office of the Attorney General would respectfully ask the committee to cover. Okay, you have the assistant. Where did I? Sorry, I don't know what. I can't find now where I got my
In the
language.
next paragraph. Your language is in the next paragraph. I see it here. In the next paragraph, it says the Office of the Attorney General wants to ensure that our Assistant Attorney General and local Board of Elections Council, who are integral to the administration of the election process, enjoy the same protections as the other individuals already listed in House Bill 585. Sorry, so I was going by the language in the paragraph before that.
Yeah, I don't remember. Council, I wrote down from somewhere, council to a local board of elections and council to the state board. And I don't know where I thought I got that from some written testimony, which I
It
can't.
could have been in the oral testimony, and I just
But
didn't write that down.
But I thought that the official who spoke a few minutes ago kind of mirrored that language. I just want us to get the correct
language right.
I want to make sure I get the language that you all want.
Okay.
When I write down the amendment.
Got it. Delegate Taylor, I think you were the maker of the motion.
I withdraw the amendment motion.
Okay. Then can I get a motion for the amendment language that Carol is speaking of, where it would include the Assistant Attorney General to the State Board of Elections, as well as Assistant Attorney Generals to the local Board of Elections?
So moved.
Yeah.
Is there a second?
Second.
Okay, all in favor, say aye.
Aye.
Aye. Aye.
Oppose? Was that an opposition, Tomlinson? Oh, no. Oh, okay.
No, that was, sorry, that's voting for the amendment.
Okay. All right, so the amendment passes. Can I get a motion to move the bill favorably with amendment?
Motion to move the bill favorably with amendments.
Okay. Is there a
Second.
second? Okay. It's been properly moved in second, and I will call the roll. Delegate Conway.
Yes.
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 Okay. Delegate Crutchfield.
Yes.
Delegate Munoz.
Yes.
Delegate Pastor.
Yes.
Delegate Phillips.
Yes.
Delegate Schmidt is excused. Delegate Simpson.
Yes.
Delegate Taylor.
Yes.
Delegate Tolles.
Yes.
Delegate Tomlinson.
Yes.
And Delegate Valentine.
No.
Okay. All right.
Nicole, did you freeze?
She did.
Now, I know we have at least one other bill that we'll be reviewing next week, and there may be others coming down the pike. So I want to thank, oh, did I just freeze?
You're good now.
Okay. So thank you guys so much for taking the time out this afternoon, and we will meet again next Monday at 4 p.m. via Zoom. So thank you all and have a great afternoon. I'll see you this evening on the